For now, Justice Joseph Kurian has written a letter to the Chief Justice of India, Dipak Misra, asking him to respond to the Judge Collegium's recommendation for Supreme Court's judge. In his letter, Justice Kurian has asked the CJI to urge the government to respond to the Collegium's recommendation to elevate a judge and a senior advocate to the Supreme Court. The recommendations were made in February. In his letter, Justice Kurian has written, and I quote, "It is the first time in history of this court where nothing is known as to what has happened to a recommendation after 3 months," unquote. Justice Kurian also asked the CJI to establish a bench of 7 senior-most judges to take up the matter of the government sitting on the 2 names. A copy of the letter has been sent to the other 22 Supreme Court judges. Indian judiciary's internal tussle and now its tussle with the government have been in the news since January this year. 4 senior-most judges of the Supreme Court held a press conference in January at which they claimed that the CJI was keeping senior judges from hearing important cases. Just this week, a bench headed by Justice Misra reasserted the powers of the Chief Justice as the master of the roster and the first among equals among judges of the Supreme Court. And to bring us more details on this story, I am now joined in by our political editor, Mr. Kartikeya Sharma. Let's quickly go across to Kartikeya. Kartikeya, this letter that Justice Kurian Joseph has written to the CJI, it's sort of emblematic of the internal tussle that the Indian judiciary is facing. Don't you think so?
See, if you go by the reports, I think what is very, very worrisome is that the debate within the judiciary is not ending. Collegium is about brotherhood, and the collegium is also about trust. And what has happened is that in this case, the letter has gone and the senior judge is saying that this decision was taken by the collegium and it has not been implemented. Now, Akansha, you have to see this in context of the National Judicial Accountability Bill. Now, National Judicial Accountability Bill would have done away with the collegium because collegium takes all the decision about the courts. Collegium decides which judge will go where, which important cases, about the important cases. Though the CJI is the master of roster, but collegium decides how the judiciary, the higher echelons of the judiciary function. Now, in NJAC bill would have completely done away with the system. So what is happening is now the people who are part of the collegium are challenging the collegium itself, saying that the collegium, despite collegium's recommendation, the CJI has not implemented it. So there is great divide between the judges, and the divide is not only on seniority or in cases being given to junior judges, but it is also faith. And I think the reason why executive has stayed away from it is that this debate historically goes back to 1960s and 70s, and they don't want to give this signal, Akansha, that executive is interfering into the judiciary. Indira Gandhi at a particular point of time spoke about committed judiciary, and after Keshwanand Bharti case, when the center was defeated and Keshwanand Bharti case upheld that the basic structure of the constitution could not be changed, Mrs. Indira Gandhi appointed a person as the judge of the Supreme Court of India who was 4th in line if I am not wrong. So 3 judges senior to that judge had to put in their papers, they resigned. So it's not as if this conflict has occurred for the first time. Issues have always been there, but this time they persist and they continue to embarrass. But a lot of people in the government say that these differences should not tarnish the image of judiciary, because judiciary is the most important institution of democracy, because it's the fulcrum on which the powers of the executive and legislator is divided. It's the fulcrum, and if there is a problem with the fulcrum, then you have the problem with the basic structure of democracy.
Right. Kartikeya, clearly we can say that it's a fight for judiciary's independence and autonomy.
Well, see, it is a fight. There are 2 things here. It is a tussle for how judiciary should function. There are difference of views which have come up. Those views have been reported. But the problem is also that the judiciary in itself and its functioning has to be above suspicion. if you start questioning judiciary or the importance of or the high echelons of judiciary, then it's about playing with people's faith. This cannot happen, because ultimately the word of the Supreme Court is where all the disputes must end. It has to be respected. It protects the constitution, arbitrates, and has taken a lot of progressive steps where executive and legislature has failed. So that way judiciary is very, very important. But the problem here is that because executive doesn't want to interfere in it, the mechanism which pre-exists within judiciary, they are not being able to resolve the differences. And I think that's where the problem is.
Right. Absolutely agree with you that they are not able to resolve the differences in terms of the mechanisms that exist within the judiciary. Thank you so much, Karthikeya, for bringing us those details.